And the other more common situation is, can you just, under what circumstances can you say, guideline is fine, and for the ordinary case, this isn't an ordinary case. And that's the second case, Gall versus U.S., involved a young guy who was in college at the time of his offense, 20 years old, and he was basically a campus ecstasy dealer. And he was involved with a pretty big-time ecstasy dealer, and he sold a lot of ecstasy over a period of time. Voluntarily, before the federal law enforcement ever got involved, the college kid decided, I'm getting out of this, stopped taking drugs. It was clear he was taking a lot of drugs at the time. He was saying, stopped taking drugs, told the guy, his supplier, look, I'm out. Don't give me any more. I don't want to sell anymore. Got out, finished college, started a construction business, and was living quite successfully several years later. Federal law enforcement starts investigating his supplier and the whole conspiracy, and they come upon him, and they say, so, what's the story? He said, oh, yeah, I did all this a couple years ago, 3, 4 years ago, and I was involved, told them everything. They said, okay. They went away. More than a year later, they come back and they indict him for his role in the ecstasy ring. And he, of course, is convicted, and the guidelines range for his sentence would have been 2.5 to 3 years in prison, and the judge gave him probation, 3 years of supervised release, saying, look, the guy actually, when he was charged, he had moved to Arizona from Iowa. When he was charged, he came back to Iowa and was released, and upon his release started another construction business, which actually employed a lot of people and was doing quite well. And the judge said, based on the fact that he's aged out of the crimogenic years, he's now in his late 20s, and he was in his early 20s and cited like medical studies about what we know about the human brain, maturing not till it's 25. Tell me about that. And that he had shown remorse and had cooperated with the police and completed college and was, completely rehabilitated and actually providing jobs for people in the community through his successful construction business, said, following the statute, which says don't sentence people to more than is necessary, considering all the circumstances, the guidelines range of which is only one, I'm giving him supervised release. Well, the Eighth Circuit has a rule, which 8 other circuits also have, that says the further you go from what the guidelines would call for, the more of a justification you need for it. And they said this is a huge difference. 3 years in prison, no prison at all. This is a 100% reduction is how the government characterizes this. And basically, different circuits have different ways of describing this. Some call it a proportionality rule. Others, I think the Eighth Circuit calls it an extraordinary circumstances rule. Extraordinary divergences require extraordinary circumstances. I love the Seventh Circuit's version of it. It says a World Series variance requires a World Series justification. And so the question is, how much of a gravitational pull is the court going to say the guidelines have to have under a reasonableness standard? Well, the court, and I'm calling both of these cases for defendants, not for the reasons it might be reported. That is, these cases have a very high political meaning about the extremes of the war against drugs, about the effects of mandatory minimums and drug sentencing in general, and the crack powder disparity in particular, mass incarceration of minority people. That has nothing to do with why the court will say defendants win if they say defendants win. It has to do with the idea of how important the judge's determination of facts is allowed to be in setting the sentences. And Scalia and Thomas are 2 of the ones who have the most extreme view on this, and I think are going to say that this violates the Sixth Amendment for sort of technical reasons about their reading about how much the judge's fact-finding can count in sentencing, not having anything to do with who wins and who loses under this view. So I think it's going to be a fractured court. I think it's going to be the weird lineups we have seen all the way along in the Apprendi, Blakely, Booker context. I think there's a question here in terms of if I'm right and the court says that judges have to have this freedom, or we know a little bit about what the court might do because the court actually had granted a different case before Gall, a case called Claiborne, and had it briefed and heard oral argument, but the defendant in that case was on release and shot and killed, and his case became moot. And the court immediately granted Gall, also from the Eighth Circuit, to replace it. But in oral argument, the question is how much of a gravitational pull does the guidelines have to have? And I love Kennedy's line. He said, like, does it have to be, like, as weak as the moon's gravitational pull? So if the court decides that the pull of the guidelines can only be very weak and not strong, I think we will see to some extent a bit more divergences, more disparities in sentencing, and there will be more pressure on Congress to do something to pull the federal judiciary back in. And that's all an empirical question. You know, if the court does this, how much will they free up federal district court judges? If federal district court judges are freed up, if those 8 circuits that say the further you go from the guidelines, the better reasons you'd better have, if that's not true anymore, how much are we going to start to see the satellites floating out there away from the gravitational pull of the guidelines, and how much pressure on Congress will there be to rein in disparity? These are questions that are going to remain if the law develops the way it looks to be developing post-Rita.